Let's go ahead, please.
Thank you, Chair, and good morning, Commissioner. Good morning, Sergeant. Thank you for your attendance. I hope your attendance today is fulsome, that we get through the full committee without receiving a notice of motion to adjourn. At the heart of the SNC-Lavalin scandal, there were a number of players within the PMO, the PCO, and the Ministry of Finance. However, the principal person of interest in the SNC scandal was at all material times the Prime Minister Justin Trudeau. To you, Commissioner, the scandal is now over 5 years old. When did the RCMP interview Justin Trudeau?
I'll let Mr. Pain-Sains further discuss about the interviews, but it is 5 years old, and the matter was brought to our attention in 2019 and officially concluded in January 2023, in which we notified Madame Wilson-Raybould as well as Mr. Scheer, who had written a letter to the Commissioner Lucky at the time.
Thank you, Commissioner. The question was very specific. How many times in the last 5 years did you interview Justin Trudeau?
He was not interviewed, sir, or Mr. President.
Okay, and why not?
I'll ask Mr. Pain-Sains, who was leading the investigation, to add a little bit.
Yes, thank you, Mr. Chair. So, in relation to this, what the RCMP conducted as far as for the objective for the review of the matter, what we've done is we've proceeded with a phased approach, which initially we looked at the potential witnesses that could provide some information as far as to precision for the elements of the offense. So we proceeded in this phased approach. As we proceeded, we determined if there was any further investigative steps that were warranted given the circumstances of the case.
My time is very limited. Why did you not interview the primary person of interest? At the heart of this investigation was Justin Trudeau's political interference for his own personal gain and the gain of SNC-Lavalin. I can inform both of you gentlemen that in my over 30 years of experience as a defense counsel and as a Crown attorney, I have never heard of any investigation where there wasn't any attempt, whether they agreed to interview or not, any attempt to interview the person of interest. Was there at least an attempt to interview Justin Trudeau, yes or no?
No.
Did the RCMP obtain all relevant documents to further the investigation, including access to cabinet confidential information, simply seeking a yes or no response?
We were limited with the information that we had access to.
Was that a yes or a no, sir?
I don't know. We didn't know. We don't know. We still don't know this day all the information that's out there because some was protected.
I'll take that as a no. Despite collecting reams of evidence, including evidence from the Ethics Commissioner and testimony from Jody Wilson-Raybould at committee, why didn't the RCMP exercise its absolute statutory right under the Criminal Code of Canada to obtain a production order and/or search warrant from a justice to obtain those cabinet documents?
We weren't able to acquire or obtain enough information or evidence that would warrant us to obtain a production order.
RCMP spokesperson Christy Veenstra is on record stating that to obtain a search warrant or production order, there must be reasonable grounds to believe that a criminal offense has been committed. The evidence at hand is sufficient to convince a trier of fact. The evidence at hand is insufficient to convince a trier of fact of the alleged offense. Clearly, she is conflating the legal threshold of policing with the Crown Prosecution Service. Both of you, sirs, will agree that your sole responsibility is to determine whether there are reasonable and probable grounds to lay a charge. It is not your mandate to prove the charge beyond a reasonable doubt, which is the independent prosecution service. Would you agree with that?
I agree, Mr. Chair.
Thank you. Was obstruction of justice involving Justin Trudeau the only offense you were contemplating in this regard?
No, there's also intimidation of a justice participant.
Thank you. You would agree that the charge of obstruction is a straight indictable offense, meaning there is no limitation period, punishable by 10 years in prison, a very serious offense. You'd agree, sirs, that there is nothing precluding your service from reopening the investigation against Justin Trudeau should new evidence become available, including a release of cabinet confidential information.
I would say, Mr. Chair, with any investigation, when there's new information that arises, yes, we have a look at the investigation itself.
To quell public concern, Justin Trudeau, despite his office, is subject to the full impact and consequences of the Criminal Code of Canada. He is not above the law, correct?
I do believe I said that last time I was in front of the committee. No one's above the law.
In my experience, sirs, homicides have been investigated and prosecuted in lesser time than your service has invested in investigating Justin Trudeau. Is there an overall general reluctance in charging a sitting Prime Minister, yes or no?
I would say to that, Mr. Chair, is that we follow the evidence, and if the evidence warrants charges, we charge.
So there's no general reluctance in charging a sitting Prime Minister. Is that correct?
If the appropriate evidence is available.
Thank you. You would agree that the purpose behind the offense of obstruction of justice is to maintain the integrity of the justice system and upholding the rule of law, that all the principles that were articulated in Jody Wilson-Raybould's testimony in warding off Justin Trudeau's relentless campaign of pressure and intimidation. You'll agree with me, Commissioner, the evidence is clear. This is not a one-off. Over the course of 4 months...
Sorry, Mr. Brock, but we're over time here.
Thank you.
Okay, thank you. Next, we're going to go to Mr. Housefather for 6 minutes. Go ahead, please.
Thank you very much, Mr. Chair. Commissioner, for coming today. Thank you for coming today. I'm going to start by asking you, was the way that you investigated these allegations any different than the way the RCMP would investigate other allegations? Were you holding yourselves to a different standard?
No, I'd invite Mr. Pinson's to add, but we approach every investigation the same manner.
Exactly. I confirm, so Mr. Chair, yes, we proceed by following where the evidence leads us.
And it's not politicians to dictate to you how to do your jobs as the RCMP. You guys are the experts in terms of doing these investigations, correct, I would think?
I can assure you that, Mr. Chair, we've never been dictated by a politician how to do our job.
And you received no pressure in this case to close the investigation from the Prime Minister or his office or anyone else in government?
Not at all.
Thank you so much. And let me ask another question. When this was characterized as an investigation of Justin Trudeau by Mr. Brock, in my view, this wasn't an investigation particularly of Justin Trudeau. It was an investigation of all the circumstances, and you would have taken yourselves in the direction of if anyone that you had investigated had broken the law, you would have recommended charges against them, right?
That's correct. And I might add, Mr. Chair, is that when the first article appeared in the Globe and Mail, I was the commanding officer of the National Division, and I actually reached out to Sensitive International Investigation. I said, let's monitor what's going on here because it might end up in our wheelhouse.
100%. So you yourselves, as I understand in 2019, initiated a review based on the article in the Globe and Mail and then followed the Justice Committee, which I have all too many memories of at the time, correct?
Correct.
And my understanding is that, you know, there was a look by the Ethics Commissioner at this. And I want to make clear something, and perhaps you could also characterize that. When you breach the ethics code, and politicians have frequently breached this ethics code, it doesn't mean you're necessarily committing a criminal act, correct?
That's correct.
And could you sort of explain to us the difference between committing a criminal act versus a breach of the ethics code?
Well, if you look at the threshold for a criminal act, you need the right evidence to get the legal documents to allow you to do production order or a search warrant to eventually lay the charges, if there are charges to be laid. I must say that the commissioner for the commissioner does have power with regards to in his search, in his review or ethics review, if he does come across any criminal matters, he's to refer them to the RCMP. And in this case, the ethics commissioner, which had more access to more information than the RCMP, did not refer anything to us.
Correct. And as I recall, in her testimony before the Justice Committee, Ms. Wilson-Raybould was asked this very question, if a criminal act had been committed, and it was her view that a criminal act had not been committed, correct?
She stated that it was inappropriate, she felt it was inappropriate behavior, but not criminal.
Thank you. And in paragraph 22 of the document that I believe Mr. Pensis was one of the signatories to, it says, notwithstanding the privilege barriers, it is believed that there is insufficient evidence to obtain production orders or search warrants for additional materials based on the totality of the circumstances and the evidence gathered. When factoring the principles of full, fair, and frank disclosure of the matter, it is believed that the evidence at hand is insufficient to convince a trier of fact of the alleged offenses. So meaning that you believe that the threshold had not only not been reached to criminally prosecute at this point, you didn't even believe a threshold had been reached to ask for further production of materials. Could you sort of explain that to me?
So yes, Mr. Chair, so in relation to this, for us to obtain any form of judicial authorization, there are some preconditions within the criminal code that we have to follow. And that's exactly what we've done in this case. So these preconditions were not met, which in this case would be that we had insufficient information to substantiate an offense, which is one of the preconditions. So as such, this option, as allowed by the criminal code, was not available to us.
And that would be true of both of the different charges that you were looking at, correct?
Yes, sir.
One last question. My understanding is from reading the documents you provided that you did not feel that criminal intent, which is an important, element of committing a criminal offense in this case, was found, or that you couldn't substantiate that it was found to a level that would allow for prosecution. Is that also correct?
That's correct, Mr. Chair.
Mr. Chair, do I have any time left?
You have a minute and 15 seconds.
Okay. I would like to ask also, is there anything else that you would like to clarify based on the original questioning from Mr. Brock that I have not allowed you at this point to clarify in terms of where you were asked to answer yes or no?
Not at this time, Mr. Chair.
Okay, perfect. So one last question. When the RCMP made a determination not to interview certain people or to interview certain people, in this case, including the Prime Minister, did you base that on your normal standard of policing, based on the way you would have handled other investigations as well?
That's correct, Mr. Chair.
You did not accord him any undue deference because of the office that he held?
No.
Okay, thank you, Mr. Chair.
Okay, thank you, Mr.